All right, Carrie, maybe we give it another minute or two, or it when you deem it appropriate to convene us.
Sure. We have 18 participants, so I think we could go ahead and get started.
Great. I'll go ahead and call the roll then. So again, as with previous meetings, I'm going to call two rolls. The first will be the names of the committee members and alternates of the committee members. When I call your name, would you please say here so that we can make sure your microphone is working? Carrie Ricci and Allison Ho, co-chairs, are present. Anika Cooper?
Here.
Thank you. Emily Bremer?
Here.
Thank you. Jim Tozy?
Here.
Thank you. Jesse Panuccio? Jesse Panuccio? Kenny Wright?
Here.
Thank you. Michael Cole?
Here.
Thank you. Mark Zachowski, alternate for Patrick Nagel.
Here, Sakachevsky.
I will get it one of these days. Sakachowski. Randolph May. Robert Gerard. Roxanne Rothschild. Russell Wheeler. I know a small number of these people had indicated already that they were not going to be arrived until a little bit later in the meeting. Is there any other member of the committees whose name I did not call? Great, and like I said, we should expect a handful of others arriving within about a half hour or so. Now I will call the names of the ACUS members who are not on the committee or serving as alternates. Again, would you please say here when I call your name? Jeff Lubbers.
Here.
Thank you. Linda Jellum serving as alternate for Bill Funk. I guess Bill Funk is here.
Yeah, I'm here. She's instead of her.
Great. Nancy Griswold. Okay. Are there any other members of ACUS not on the committee whose names I did not call? Great. Well, Matt, I will turn it over to you for opening remarks.
I have none other than to welcome everyone. Good to see you, Larson, from the ABA, and thank everyone for sticking through this project. And with that, I'll turn it over to our committee chairs to begin today's meeting.
Thank you, Matt. I'll go ahead and run through the ground rules. So we have to go through this every time, whether you've heard them before or not. So please note that only ACUS members, whether or not on the committee, and their designated alternates have full speaking privileges. ACUS members include government members, public members, senior fellows, liaison representatives, and special counsel. Again, only ACUS members have full speaking privileges, but with respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points, and we will presume that the committee members consent absent their raising an objection. If any such participant would like to speak, please so indicate in the chat feature or by using Zoom's hand raise feature and wait to speak until I call on you. You can then unmute yourself, and please remute yourself when you're done speaking. Only members of the ad hoc committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you're a member of the committee. Staff counsel Gavin Young and I have a list of committee members in case you're unsure. To avoid background noise and feedback, please keep your microphone on mute and either use Zoom's hand raise feature or add a comment in the chat feature if you'd like to speak. I'll then call on you and you can unmute yourself. Please then remute yourself when you're done. For all participants, please use the chat function only to indicate that you'd like to speak, or for committee members and their alternates to vote when asked. Please do not hold any sidebar discussions or put substantive comments in the chat feature. I'd also ask that ACUS members and their designated alternates use the webcam to better mimic a meeting environment, if you can. So with that, we can get right to it. We're going to go ahead and go straight to paragraph 8, who can practice before agencies. I think we wanted to recap that. Is that right, Gavin?
That's right. Give me 1 second to share.
Sure. Absolutely. And I believe 8 was a reformulation of 6 and 7 during our discussion at our last meeting. And we just wanted to have you take a look at 8 and make sure there weren't any questions, comments, or edits for 8. Again, we're looking at 8, who can practice before agencies. Are there any comments on 8? If there are no comments or suggestions, we can move to transparency. You can see the language there at 9. Any suggestions for 9? I don't see any hands raised. Give you a moment to finish reading 9. And if not, we can move on to 10 under transparency. And if I'm moving too quickly, just let me know.
I think last time there was some discussion about having the word significant. I don't know that it's necessary, and then it's a very vague term. And I thought we had said agencies should publish rules governing.
And just delete significant.
They should publish all significant, agencies should publish rules governing representatives' conduct, etc.
Are there any comments about deleting significant?
Their rules.
Should publish their rules.
I think that's implicit, but I don't have a problem with it.
It makes it consistent with the next paragraph. It uses the same term, their rules.
Mhm.
Okay.
Any other comments on 10?
We have a hand raised from Jeff Lovers.
No, I made my point.
Apologies.
Okay. And we can move to 11 then. I don't see any hands raised, but I'll give you a moment to finish reading. And if there are no comments for 11, we can move to 12.
I don't want to be picky, but I think there should be a
11.
comma after attorneys.
I'm sorry, we do have a comment for 11.
Yeah,
After-
this is
you go
Anika
first.
Cooper. Anika Cooper. Since we have said in 10 that agencies should publish them in the Federal Register, should we say in 11 agencies should also publish, on their website?
Any comments on that? Okay, we can insert also. Any other, I think that was it for 11. We can move on to, oh, I see Emily, you have a hand raised?
I'm just wondering if we want, because we have their rules governing representatives' conduct, and then the next one is also publish their rules for representatives' conduct. Should they both be governing instead of for?
So replace for with governing in 11.
Yeah.
First line. Publish their rules governing representatives for consistency. If there are no concerns with that, we can move on to 12. And Russell, you have your hand raised for 12? Oh, your sound is not coming in. There appears to be something wrong with your mic. Okay, were there any other concerns with 12? And hopefully we can circle back to Russell. Okay. If there are no other concerns with 12, we can move on to 13, and when Russell's able to speak.
At
Do you
this
see
time,
another?
I would suggest that Russell did make a comment on line 147.
Okay.
His comment is, consider inserting "or" in the document after web page.
Paragraph 11 refers to "or" in a single document, then you presumably you want to make that consistent. Same thing on 13.
Any concerns with that addition?
You want to have there or the?
The,
And same comment for 13. Any other comments on 12 or 13?
If you want to be consistent, yeah, you add on the rest, right?
Do we need relevant in 13?
That can be
No.
deleted to be consistent with 12. Any other comments for 12 or 13? We can move on to 14. And Russell, you have your hand raised?
I did. In the comments, I said, I'm sorry for joining late. I had all sorts of computer problems.
No worries.
On page line 158, do we want to add reprimands imposed, rules violated, nature of the misconduct, and reprimands imposed? I mean, if this is an informative document, it seems to me people ought to know that too.
Any comments on that suggested insertion?
I would
And
just
you-
change it to comment, to use commas, describing the rules violated, comma, the nature of the misconduct, comma, and reprimands imposed.
Agreed.
And I wouldn't use reprimands and actions imposed or discipline imposed or.
Thank-
well, remember,
Or
we're also-
sanctions.
Sanctions, is that the word we were using? Okay. Anything else on 14?
How about any sanctions imposed?
Agreed.
And just
Anything
one caveat, remember some of the actions that we were talking about were short of sanctions, such as reminder letter or warnings. So I'm just wondering whether sanctions do we want them to include examples of where the action taken by the agency was short of a sanction, or are we only focusing on the actual sanction?
That's where actions is more important than sanctions. Actions taken.
And the actions taken, yeah.
Yep. Anything else on 14? We can move on to the model rules. Paragraph 15. Any comments on 15? I don't see any hands raised or comments in chat. We can move on to the preamble, I believe, would be next. Any concerns before we move on back up to the preamble? The preamble is we haven't looked at before today.
Bill Funk has a hand raised.
Yes,
I'm sorry, but I'd like to look at paragraph 5 again.
okay, we can pull up 5.
I think it's 5 now.
New paragraph 5.
No, I mean, it's going to be,
Agency action in response to a violation of rules, the
yes,
first.
go down. It's here. It's this one, rules. Number 6 now, sorry. For rules applicable to attorneys, agency rules should identify any reciprocal disciplinary procedures or referral procedures. And it wasn't clear to me exactly what it meant by identifying them. I would wonder if we shouldn't say agency, for rules applicable to agencies, agencies should consider adopting reciprocal disciplinary procedures or referral procedures. And then we describe what they are in the preamble. So what they are is made clear, but I mean, I don't see any reason that they shouldn't consider adopting them.
Consider whether to adopt.
Well, consider whether, either way.
Bill, what about leaving in identify and say identify and consider whether to adopt? I mean, why don't you identify them first and then consider adopting?
Well, maybe, but I think if you just said consider, they certainly have to identify them before they consider them. So I think if you say they should consider them, it probably means that they should identify them. I'm either way to me, but it just seemed to me more than just identify was important.
Did anyone else have a comment on 6? I know there are other hands raised.
I think you should say at the end, if applicable, or if any.
And he's good, yeah. No, you already have any in there. It's whether to adopt any. You don't need the if any.
So the language as is on the screen now, or was there something else?
I still think you should say something to the effect of if applicable at the end. Because even if you identify it, it may not necessarily be applicable. There may be variances or reasons why that just because one agency does it, it may not be something another agency should. I know we have consider, but that is on a little more clarity, I think.
Well,
You've got applicable twice now.
Right.
and I don't, you see, it says whether to adopt any reciprocal disciplinary procedures or referral procedures. So the any seems to cover the if applicable. I mean, if they aren't applicable, then you wouldn't adopt them.
Yeah, I agree.
I mean, it just.
Okay, I can live with that.
Okay. Okay, anything else on 6? I see we have other hand raised. Is any of that for 6? No, okay.
Yeah.
Yes, go ahead.
Well, the comments I distributed last night concern, if you want to go through this section right now, we can, if that's where you want to proceed. I have a variety of comments, and it's up to line 111 to start with, the introduction. Agency action in response to a violation of rules, that assumes there's been a violation. It's inconsistent with C, who adjudicates the complaint. I would say agency in response to allegations of violations, something along those lines. We've already assumed here that there's been a violation, and I thought the whole purpose of this was to determine if there was.
So you would.
Response to a complaint of rules violation or allegation of rules violation.
I don't think that's true. I think this whole thing is what happens if there has been a finding of a violation, not whether there's been an allegation.
Well, we say who adjudicates the complaint in number C. It's the purpose of the adjudication to determine if there's been a violation. The complaint is valid.
Yeah, that's right. 7, yeah.
Yeah.
7. Okay.
In response to an alleged violation?
Anything to make clear that we haven't already decided it, that the agency hasn't decided before it begins the process of deciding it.
Okay. And
Should-
Jeff, you had a hand. I'm sorry. Go ahead, Bill.
I was going to say, it seems to me that then 5 and 6 are sort of out of place, and what's now 7 should come first. Because 5 and 6 assume there's been a violation.
That's right.
So move 5 and 6 to come after
7.
what's
Yeah.
now 7.
Is it, would that be fixed by just adding alleged before violation in 5?
Yes.
Can you say that again? On my end, you cut out.
There we go.
Any comments on that change?
But I did have another comment on what's on 5, though.
Sure.
It says actions an agency may take. May is always an ambiguous word, but consistent with their authority to do so. It seems to me that embraces the whole idea of may take. What actions an agency may take, doesn't that imply is authorized to take, or does it mean an agency might take or could conceivably take? Is may a description of what's authorized, or is a may a description of a contingency? If it's the former, then consistent with their authority to do so seems to me to be repetitive.
I took it as a contingency. Any other comments on that? Is that how others saw that, or do we need to make an edit there? So how would you change that?
Well,
Professor
it gets a little wordy, but something might take, may and might are funny words.
Mhm.
Could conceivably take, or I don't know, others are better at this than I am, but I just think may implies is authorized to. And if to the degree it implies that, it makes that added phrase repetitive.
I see the added phrase as just limiting, sort of delimiting the may, which clarifies the may to the extent it's ambiguous. I mean, it seems consistent with their authority to do so. Seems
People are happy.
put a box around it.
Okay, I've raised the point. I don't, if people are happy with that, I don't want to push it. I do have a few others.
I think 5 seems clear to me.
Okay.
Randy's the expert on the word may.
Yeah, no, I'm not going to say too much else today, but if anyone wants to discuss may, I'm going to jump in.
Well, if you're happy with it, I am.
And by the way, I don't think I was here for the roll call, but just for purposes of compensation, when that comes around later, I am here when you total up the pay for these meetings.
You mean the fee?
The fee or pay, whatever, however we get paid for. That's a joke. Move on.
Can I speak against an alleged violation? I mean, not there, but in the paragraph 5 itself. I mean, what this originally said, what I think it intended was, after you found a violation, what might you do about it? What actions can you take? And as we discussed, you may impose fines if you have the authority to do so, blah, 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 blah. But are we talking about an alleged violation or after a violation's been found in 5? I thought it was after a violation's been found.
I agree, because number 7 covers what the process is if there's an allegation. So maybe we should go back to Bill's original suggestion of switching.
And that's why I thought 5 and 6 should go after 7.
Mhm.
That's fine. The only thing is then where 5 now talks about rules that we haven't actually told agencies they should address. Which, I mean, maybe that's fine, but it does seem a little odd.
Agencies should adopt rules that clearly indicate how the disciplinary process works.
Well, the rules are the first heading. Rule, adoption of rules, consideration and conduct, and then rules of conduct. So we've got the referent in the headings.
Or should clearly indicate.
Previous headings.
Agencies should clearly indicate how the disciplinary process works. Or agency rules should.
I apologize. I was booted out of the meeting. I see we've moved on to 5.
Yeah, to briefly recap, Karen, I guess we moved 6 and 7, or we moved what we're above current 5 down to 6 and 7, and then we're wordsmithing the first sentence of new 5 to make clear that we're talking about rules that agencies should adopt.
Got it.
So how about on it? Yeah, take out that and then say, among other topics, the agency rules should address or something like that.
Any comments on adding agency rules?
Gavin, one small cleanup thing. Can you remove the alleged in number 6? Just make sure that we get that.
Yeah, I was going to follow up. Bill, that's consistent with the moving of the paragraphs, right?
Correct.
You need an A in the case of a violation of the rules? Or do you? Maybe not.
I think that's right. I think
Yeah, okay.
I had another comment about this.
Go ahead.
The preamble, to which we haven't gotten to yet, indicates that that the agency may issue warning letters. Rather than start a full adjudication on a complaint, just advise the representative informally or perhaps even formally that there's a problem. And there's no reference to that in here. And I think consider whether there should be adding something along the lines of the use of informal or formal warnings in lieu of adjudication, depending on such factors as severity or frequency of the conduct. That's what I submitted last night. I'm not wed to those words, but it seems to me, since the preamble makes reference to this informal resolution whenever possible, this paragraph ought to at least take some recognition of it.
That makes sense. We can add it as an I.
An I or either an A. I mean, at the very start of the process.
Oh, because it is, okay. Well, it would go after who can make a complaint, how notice of a complaint, who would do, so I think it would be.
Yeah, but that assumes the agency has to wait for a complaint even to do that. And I would think that there could be instances in which the agency officials would get wind of something and say, wait a second, before there's a complaint filed, you ought to clean up your act.
Any comments on that particular addition? There were hands raised. before the addition. Anything else on A?
Can I just raise with Russell really quickly? Is adjudication the best term
No.
to use there?
No,
I think maybe,
maybe just take it out. Use of formal or informal warnings.
yeah. Yeah, I think that's better.
I mean, you get real technical and say, no, I think that conveys it. And on the same topic, do you want to say anything specifically about the ability of agency officials to take action even if there isn't a complaint? It's implied by A, but it's not, I'm thinking of disciplinary in the judicial context, which recognizes chief judge's authority to basically take, you know, what they say, identify a complaint even one hasn't been filed. I mean, it probably just is implied in A.
Someone's convicted of a crime, you don't have to wait till somebody makes a complaint against them, right?
Yeah.
And also, do we want to use the word disciplinary? I thought we were moving away from using the word disciplinary.
Yeah, it's a good point, Carrie. We could maybe, committee on style could maybe rephrase it to more closely match something like the heading, clearly indicate any actions the agency may take in the case of a violation of the rules or something like that.
Would sanctions work?
You mean like
The
replace
sanction
disciplinary
process,
sanctioning process?
the sanctioning process or the sanction process, because that doesn't necessarily mean that you're going to go all the way to sanction, but it's still part of the process.
Okay, we can leave that for the committee on style, perhaps, unless anyone feels strongly about resolving it at this moment. Okay.
And one last thing, should this itemization include anything about the range of sanctions available to the agency? I mean, if you're sort of laying out due process here, do you have to tell people what you're likely to face if you commit misconduct?
That's what's in the following paragraph that we moved. Rules should address what actions an agency may
Okay,
take.
that's right, okay. When it is previous place, it looked to me like it was a description, the rules was a description of the procedure.
Okay.
But no, that fixes it. By moving it, it fixes it.
Okay, great. And Jeff, I think you've had your hand up.
Yes, you don't need number 8 anymore, by the way. Down a little bit farther down.
Oh, yeah, delete that.
Yeah, so my comments are a little bit earlier in number 4.
Well, excuse me, before we leave
Yeah.
5, I just wanted to point out, Russell put in 5, or suggested putting in, and we did put in this informal formal warnings because of its mention in the preamble or in the but actually in the preamble, it's used as one of the things you do if you found a violation. In other words, it says they must determine how to enforce the rules. Agency may do so in various ways, ranging from warning representatives to disqualifying them from appearing in the current adjudication or future adjudications. It wasn't clear to me. I mean, I thought that was after somebody had been, a violation had been found. You could make a warning as opposed to a sanction, in which case it shouldn't go here. It shouldn't go in 5, which is the process for adjudicating the complaint. Russell's point was this was in lieu of adjudication. We took that language out, but that was the idea. But that's not, I think, what the preamble intended. So it's just, it seems to me that there's a fundamental issue here. Do you want to include the idea, say the agency should in fact not just consider, but should in fact use informal warnings as opposed to a disciplinary proceeding.
Any comments?
No, I think the point is well taken. Moving the paragraphs around changes a little bit, but I just think somewhere or other, not in the preamble, which of course is not part of the recommendation, there ought to be a recognition that there are the actions available to the agency short of actually imposing sanctions. Maybe it should go somewhere else. I don't know.
Well, if I could make a suggestion, then if you went to new six, the next paragraph,
Number 6.
yeah, number 6, to address what actions an agency may take in case of violation, which may include, including informal warnings, short of sanction. I mean, I put the style people to make it sound better, but I think this is where the idea would go. I asked Russell if this would.
I agree. I'd make it plural sanctions. No, I think point's well taken. As long as it's covered somewhere.
Mhm.
Then you can take out a,
And so take out, yeah, A. Take out 5A. Line 118. Okay. Okay. Jack, did you have a comment on this portion?
Yeah, I'm sorry, I'm just jumping in, so maybe this is covered somewhere else, but my reaction to this is that you would also want to add a phrase that said, and the range of available sanctions or something like that, because you don't want to make it seem like you're saying there should be a preference for only informal warnings. Including informal warnings short of sanctions and the range of available sanctions.
Agreed. Any other reactions to 6? Okay. And Jeff, I think you were beginning to comment earlier.
Number 4 first, just a little style point.
On 4.
Instead of on the first line, instead of between, shouldn't it be among? And then, if that's okay, I have
Sure.
a question about 3G.
Okay.
I'm just wondering what powers, maybe this is in the report, but what powers agencies actually have to prevent attorneys from withdrawing from their representation without their permission. So in the middle of a case, if a lawyer says, I can't represent this person anymore for one reason or another, so I'm withdrawing. I mean, can an agency say, no, you can't, you're violating some duty to us by withdrawing? I'm just.
So our agency actually has a scenario like that, where we allow the representative to withdraw, but we could potentially engage in sanctions unless there's a very good reason, especially if it's close to the hearing date or later.
What are some of the good reasons? Like illness or,
It could be, it deliberately says good cause, and that's up to the ALJ's discretion, depending on the factors. You don't want to identify those because there'd be a myriad of ones. I don't recall if they give examples.
Well, then maybe it should say without authorization or good cause or something like that.
Yeah.
Any reactions to that?
What is the I don't know if George knows this. I mean, this is a common phenomenon in court litigation. What's the phrasing that's used in that context? You can't just leave a client hanging in litigation. I don't think it should be any different in the agency context. Is there a standard formulation?
Well, can I answer that? So there is an ethics rule that basically says that you have to obey the rules of a tribunal concerning withdrawal, and tribunal is defined to include federal agencies acting in adjudicative capacity. So in addition to Social Security, the only other prohibition that I'm aware of is the Department of Labor has one that basically says the judge may deny a representative's motion to withdraw when necessary to avoid undue delay or prejudice to the rights of a party. So that's their formulation.
I just can't imagine that, I mean, that an attorney couldn't say, okay, but I'm exercising my if they
Well,
really-
this happens in courts. I mean, courts can
Yeah.
tell an attorney you have to stay in, you know.
do they really do that though, or do they just say you have to get a substitute, or I don't know. Well, maybe the ABA is position on this.
The whole point of this rule is, I mean, not just ours, but the ethics rule that George is referring to, is to assure that it is done under supervision so that you do get substitution or everybody understands what's going on. You can't just not show up and say, well, I quit. And that's it. That's a violation of good conduct for attorneys. So I mean, I think without authorization or cause are good additions, but I certainly think this ought to stay in here.
And courts do police it. There's no question about that. Enforce that obligation.
Kai, did you have a comment on this?
Yeah, I think it may be worth clarifying authorization from whom, like without agency authorization or something like that. But I'm a little concerned about saying authorization or good cause, because apparently what it is in Social Security is that the authorization is based on whether there's good cause. So sort of saying agencies may wish to consider withdrawing from client representation, it should be either without good cause, as defined by the agency, or without authorization. And I'm just a little concerned about having both of those. So if you want language, it could be without good cause as defined by the agency and take out authorization. Maybe that makes it more clear. And then again, it's not that the person might not show up, the attorney might not show up, but then there will be a sanction, that attorney may not be able to, practice before the agency, or there's a written reprimand, whatever the range of sanctions is.
My only concern about that is how many agencies have defined good cause.
Apparently, it only seems maybe two.
Right.
I know, but right, what we're trying to say to these agencies, you may not have developed a set of rules about what to do, right? And an agency might have thought, gosh, we don't have any such rule. If someone withdraws without good cause. I think we're just saying, and I think you started with, is this in the report? And if it's not, I think it should be, right? To give agencies the information that actually some agencies do have that in their rules.
Yeah, I can add that at USDA, I have seen this happen, even though it's not defined or described in our rules. I have seen the ALJs use their inherent authority to address this type of situation. So what we're doing here in the recommendation is just making it clear to agencies that this is something that can be included in their model rules. I see other hands are raised. Randy, did you have a comment on this portion?
Yeah, and I had tuned out a bit earlier, but I think you were just getting towards what I was going to say. And that is, this came up earlier, maybe in the first meeting. This section deals with topics that the agency may wish to consider. And, when you look at how we've dealt with these topics going down the list, and we've reduced the extent to which we tried to deal with all the situations with several of them. And so as we were talking about this, I was thinking it should, if it said something like just withdrawal from client representation or circumstances relevant to withdrawal from client representation, that's consistent with what we're trying to do to prompt the topics rather than trying to parse through what constitutes good cause or authorization. It doesn't seem like that's what we're trying to do here in this section.
That's a good point. So we would just be raising this as a topic that should be addressed.
Well, I think there's a problem with that because
Mhm.
all the others are inherently bad, right? Unauthorized ex parte conduct, conduct that disrupts. But withdrawing from client representation is not per se a bad thing. It's withdrawing from client representation without authorization or without good cause. That's what is, you really need that in there because every other one of these things is per se bad.
Negative.
But yeah.
Any other reactions to that? I think, Jack, you had your hand up.
How about improper withdrawal from client representation?
Reactions to that?
The reason I say improper is because it maybe there's rules, it just maybe they need permission, it may be a custom, it may be a practice, but we're trying to say that, you know, there are situations where an agency may view it as improper for people to withdraw, and they ought to specify those in advance in these rules.
So perhaps as described by the agency or something could remain in there?
I would just say improper or unauthorized withdrawal. I just think simpler.
I think Jack's solution would mean you wouldn't need the without cause or authorization. You could strike that. You make it inherently bad by saying improperly withdrawing.
Improper withdrawal.
Improperly withdrawing.
Okay. Improperly withdrawing from client representation and delete the rest.
Yeah, leave it to the agency to define what's improper.
Yeah, this is high. I like that. Because again, you think about on the floor, on the plenary, and what does that mean without authorization? This is just following improper withdrawal, and it sends a signal to agencies that haven't thought about that. So they don't have even any rules about authorization or good cause. So you just need to change withdrawing to withdrawal.
Okay.
Oh, I'm sorry. No. Improperly, you changed it. Improperly withdrawing. You were fine.
Improperly withdrawing. Yeah.
I'm okay with that.
Okay. Randy, you still have your hand up?
Oh, I'm sorry, I don't. But you could, if you wanted to be consistent with J right below that, maybe you would consider improperly seeking. Well, no, it's okay. Improperly withdrawing. It's fine with me. I'll lower my hand.
That looks like a good resolution. Were there any other comments on this specifically? And if not, I think Russell, you still have your hand up. Did you have a new comment?
It's a small one online. I think it's 98. Oh, yes, line 98. This is just people's tripping over things. Rather than other agency rules, I'd say other rules of the agency. Other agency rules, although the next sentence clarifies it, it could be referred to the rules of other agencies. If you say other rules of the agency, then it's clear and the reader doesn't have to stop and, ponder what that means.
Sure.
That's all. I mean, it's a small point.
Yeah, no, thank you. Is there anything else before we move to the preamble? I don't see any hands raised or comments in chat. Can we move to the preamble? And I think, Allison, were you going to take over for the preamble?
I am happy to do that. So again, as Carrie mentioned, this will be the first time that the committee is seeing this. So I don't want us to get bogged down, but I also want to make sure I'm giving people enough time to read and review and comment. So I see Jeff already has his hand up. So Jeff, do you want to weigh in?
Well, first of all, it's an excellent draft, so I commend the drafters of it. I have a couple of really tiny things, but one conforming change is on the very end of the preamble where it says that the office of the chairman recommends that the office of the chairman prepare model rules. That's not what the recommendation does. It just recommends that office of the chairman consider preparing. So that's just a conforming change with the actual recommendation. And the other things are really super picky style points, which I don't think I really need to raise. Maybe I'll mention one on line 22. This is more of a question than where it says courts have consistently found such authority inherent in agencies' general rulemaking power. I thought there might be a need for a cite there. And I didn't go back and look at the report. I probably should have, but I was wondering whether this was referring to the so-called housekeeping rulemaking statute, which is 5 US Code 301. And the odd thing about that is it only applies to departments, but it's an example. So I suggested maybe putting a footnote there and saying something like, CEG CEG 5 US Code Section 301 parentheses the quote federal housekeeping statute, close parentheses. And then if you'll indulge me for one other one, I mean,
Certainly.
I'll trust Gavin to make the little style points that I made, but on 28, where it says will also apply to non-attorney representatives. A non-attorney always grates with me, but we use it so much in this recommendation, we can't get rid of it. But I thought maybe we could say there are other representatives. That's one that we don't need.
That strikes me as a good change, Jeff.
Okay, so
I share your distaste for non-attorney.
okay, and Gavin, I made two other little kind of punctuation type ones, which I assume the Committee on Style can review.
We will.
Bill, I see your hand up.
Yeah, I have a substantive point on line, what used to be line 38. See if it's still 38. 39 now, actually. The agencies also must decide. I think it should be should decide. Agencies also should decide.
I think that's fine, Bill. The only suggestion, so we try to sort of avoid should or should consider to the extent possible in the preamble. Agencies will need to decide or something like that. Is that better?
Ought to decide?
Fine.
This is Hai, if I could just speak to that a moment. I'm just a little concerned, unless there's a reason that I don't understand, to change that particular one from all the others, right? So once agencies have decided to adopt rules, they also must determine how to enforce them. Now they can do that in various ways, and here it is. And then starting from 37, we're telling the agencies certain things that they must decide. they may decide not to, right? Must satisfy themselves they have the legal authority. Agencies also ought to decide. I mean, I guess that's right. If we think as a policy matter that this is not something that they must decide, you know, A or nay. I just want to make sure that we understand that we are actually making something of a policy decision here. That we're doing it differently than 38, 37, 38. And maybe that's right. You know, they must satisfy themselves. They have the legal authority and they ought to decide whether to implement the program for reciprocal discipline. I guess I'm okay with that. Looking at that, I just wanted to make sure we all knew we were doing that.
Is there anything intentional behind that change? Or, I mean, it strikes me that works just as well there as elsewhere. Maybe I'm missing something. So ought to is awkward.
The only reason I made the change is because we changed the substantive provision in the recommendation to should consider whether to adopt a program. And so then the question was, should consider to adopt seemed a little different than must decide. And maybe it isn't, maybe it's the same. But that was the reason I made that suggestion.
Although doesn't it imply that they should decide one way or the other? You know, the decision may be not to do that, but they should make a determination. So must decide doesn't strike me as sort of pushing in any one direction or the other.
I received from my change, put it back to must then.
Bill, this is Randy. I'm just going to chime in because I was sort of chuckling to myself. Anyone that's been around ACUS for a long time, Matt and Jeff, I think can confirm this. There have been hours and hours and hours of discussion in different contexts and recommendations about whether the conference should say should or ought or must or should consider. And they've been at times metaphysical so that it would have been easier to call in some Jesuit priests to decide the difference. But this is this is all in good keeping with those discussions. And I'm just going to watch to see which way it ends up.
I don't think we struggle as much with that in the preambles as in the recommendations themselves. I just read this as saying, if you decide to adopt rules, you must determine how to enforce them. It's almost just a statement of fact.
So this is Hai, if I can jump in again. I actually think that not having a difference between the preamble and the recommendation is fine. Is in fact, it's important, I think, not to. So I think it was, Bill, I think we should track, you know, agencies must satisfy themselves, they have the legal authority. Agencies, whatever we say, should also consider whether to implement a program. I don't know, because I don't see the recommendation here, but we may want to just take a look at the recommendation right now. Because as you heard, I spoke first to say, why are we making a difference? You know, that's a policy thing. And then I thought, well, you know, maybe we do want to say, you know, you don't really have to, you know, you do have to decide, but it may add this extra weight. But in any event, as soon as I heard that the recommendation is different, I think there is a problem with having different language in the preamble and the recommendation. So if we could just see the actual recommendation on that. Yeah, thank you.
It's in 6, I think. Yeah. Oh, 7.
It's
Oh,
in 7.
7.
Rules applicants should consider whether to adopt any. Well,
I think
know what?
determine, I think determine is a little softer than decide.
Yeah. So now the way that this is done, I think you're better off in the preamble being consistent of these are things you have to figure out. And then you can look at 7 for, the fact that we're softening it about whether to consider. But then what you just said, Jeff, I think is right, must determine whether. Is that sort of more, I mean, I don't know if that's so, no, not in the recommendation. But just right up there in the preamble. I think where we are is we could just stick with must must, well, how do we have it? Must decide.
It just says
determine?
must decide, though. What's the difference between that and
Yeah.
determine?
I don't, yeah, I don't think there is.
You were the one who
I-
used the word determined, Matt. That's why I picked up on it.
Yeah.
Yeah, but try to explain the difference between decide and determine.
Well, decide
here.
sort of
So
an
it-
up or down sort of thing, and determine, well, what should we do?
Yeah, that
I
may
see,
be,
I see George's hand up, and I think he's going to say something substantive rather than what we're talking about.
Yes,
Okay.
George.
Bill hit it right on the head. I do have a substantive point about now that we have changed the heading of that, the whatever paragraph 7 is now in, to talk about responding to allegations. I'm not sure that reciprocal discipline goes there anymore, because reciprocal discipline is about not about misconduct in this particular proceeding, but it's about enforcing a determination made by another agency or another entity here. So I'm not sure it really goes in this section anymore. Arguably, it should go in the qualification section. But
well, we moved 6 and 7 from where they had been
right
when we changed allege, and maybe we need a new heading here that says actions in response to a violation as opposed to allegation. So
Mhm.
in other words, before 6, you'd have a new heading. That would be agency action in response to a violation.
Comments, reactions to that change?
The previous heading might need to be changed a little bit too then. Agency action in response to allegations of violation of rules. Just because it makes the dichotomy a little clearer. I think if you talk about somebody who's made an allegation as opposed to just alleged things.
I think Emily Bremer may have a comment. No.
Yeah, I was just going to suggest that we could totally change the heading now that we've, I mean, it could just say the disciplinary process or rules governing the disciplinary process or something to that effect, because that seems to be everything that's left in that category now. So why get wrapped up in alleged violations or whatever? No, not there, up for what is now paragraph 5.
Speaking as a member of the committee and not the co-chair, just flagging the use of disciplinary there, which I think maybe the committee on style was going to go back and play with, but just wanted to flag that there too.
I'm not sure I understand why we're reluctant to use the word disciplinary or discipline. Uh, I know the ABA makes a distinction between discipline and sanctions, but the Agency Practice Act actually uses the term discipline. So I'm not quite sure why we should be afraid to use the term that's used in the federal statute.
Thoughts, comments, reactions on Bill's point?
I agree.
And the ABA, that distinction that was drawn, I'm not even sure that that sort of resides in any kind of official ABA documents. It's just sort of an informal terminology that's used to distinguish between two different things. That was my understanding from, I think it was Ellen or Mary's comments.
Any contrary views on that point? Or are we, sounds like we're moving in a direction of being comfortable with using disciplinary throughout. Just want to give anybody that doesn't agree a chance to weigh in. All right. Seeing no objection, do we want to maybe scroll down and kind of take another look at sort of how this looks in terms with the new heading?
Can I ask a clarification just from the ABA perspective? When you talked to Ellen Rosen, did she recommend that the term discipline be avoided in these, or did she? Because I know she was on the last call and I was out of town at that time.
Matt, do you mind weighing in on that? Because I don't know that I know there was a discussion about that. I don't know that I was part of that discussion. I don't want to misspeak.
Well, this was the context, as I recall it. Reeve, jump in. This is what I recall. I had raised originally Mary or Ellen had said something to the effect of that federal agencies should not be disciplining lawyers. And I raised the question about, well, what do you call what happens in say a federal court when a judge disqualifies a lawyer, say for having a conflict of interest or whatever it may be. And Mary says, well, I think of that more of as sanctioning than discipline. That was the context in which that arose. I don't know if that distinction resides in any ABA resolution or any authoritative written document. I just thought that was sort of her colloquial usage to describe the distinction. Reeve, you've been a little more immersed in this than I have. Do I have that right, or do you want to add anything?
No, that accords exactly with what my understanding was as well. And it didn't necessarily reside in any form of resolution. She was just sort of making that possible distinction.
And let me say, she did not make a recommendation at the last meeting to do anything about the distinction between discipline and sanction.
I guess one of the other distinctions between what a federal court might do and what a federal agency might do is, don't the federal courts typically try to apply the state court ethical rules and disciplinary rules and generally incorporate those into the federal court rules, while the federal agencies, with a few exceptions that the professor identified, do not. So I'm not sure if that might be a great analogy of what a federal court does versus what a federal agency might do. We're in a little bit awkward position, as I sort of explained in the first meeting, because although we very much appreciate being included in this, the ABA policy still calls for lawyers to be disciplined exclusively by state disciplinary authorities. And so while we appreciate being able to observe, it's hard for us to make formal comments because we sort of object to what the general practice has become with federal agencies adopting their own disciplinary rules. So we sort of explained that before, but to the extent that the ACUS recommendations end up being as harmonious with the ABA principles, or at least not in conflict with the ABA principles as possible, might have a bearing on whether the ABA ultimately endorses this or at least doesn't oppose it. So that's the only reason I even raise these issues. And I appreciate your indulgence because I know I'm not a member of the committee, but anyway, I just wanted to share that observation.
And I see several hands up. Let me start with Robert. Did you want to weigh in? And then I'll move to George and then Hi.
Yeah, sure. I actually was also struck by the difficulty wrapping my mind around the distinction between disciplinary rules and sanctions. And I'm even wondering if we need to at least drop a footnote toward the end of the preamble to explain that this recommendation does not address any inherent authority granted by law or regulation to a hearing officer to control a hearing, including the authority to sanction a party or a party's representative.
I thought we actually did take, I think this was dealing with the ability of adjudicators to take action that would be subject to these rules.
The preamble says that agencies have this authority to beginning as a general matter.
Yes.
But aren't they going to?
And I don't think that is a point of disagreement with the ABA either, although someone can correct me on that. My understanding is that I think that's kind of the origin of the distinction between the ABA's distinction between sanctioning and disciplinaring is they do not object to agency adjudicators being able to sanction in the course of a proceeding.
I think that's consistent with what our expert Ellen Rosen said in an earlier meeting. Although I'm with the Governmental Affairs Office, Ellen Rosen and Mary McDermott are with the ABA Center for Professional Responsibility, which is the office in our Chicago headquarters that sort of are the experts on ABA model rules of professional conduct, ABA lawyer regulation, lawyer regulation issues and whatnot. So we tend to defer to Ellen and Mary on sort of the technicalities of how the state court lawyer regulation and disciplinary system works and sort of the proper terms to use, et cetera.
Right.
But you're right. I think she did make a distinction between sanctioning, which she and her colleagues had no objection to, and disciplining, which raises issues of separation of powers, whether agencies can preempt state court disciplinary authority, et cetera. So it gets in kind of messy issues if you use the term discipline as opposed to sanctions.
Except that.
Right, George,
except that,
I'm sorry.
It just.
Go ahead, Bill.
This distinction between sanction and discipline is working knowledge of the ABA experts. It is not something that is written in writing in law, regulation, or statute.
I think the terms discipline might be, and I would need to consult with Ellen on this, but I think they might be used generally in the ABA's lawyer regulatory materials, like the model rules of professional conduct and other ABA materials that have been embraced by the state Supreme Courts and made into state Supreme Court binding rules. So again, I would have to defer to Ellen on whether that's a term of art beyond just ABA experts or whether it actually is reflected uniformly in the ABA's model rules and other things which have been largely embraced by the state Supreme Courts. Perhaps I can talk to her about that offline and then let you. I guess this is the last meeting, but perhaps I can talk to her offline and share what she says with Gavin and Matt, perhaps.
Thank you, George. I think you're next in the queue.
Yeah, I just wanted to make a point about the terminology of discipline. And if you look at, for example, the rules of court of the District of Columbia or the Southern District of New York, I haven't done a survey, they actually have within those federal courts what they call a disciplinary system. And they have procedures for discipline. They call it discipline. And so they're using the term discipline within that system as distinct from sanctions such as Rule 11 sanctions or discovery sanctions or something like that. So they have their own internal disciplinary system. Now, you know, the ABA has a view about whether agencies can do that, but that is the terminology that is used in the federal courts.
Thank you, George. Hi, I think you're next in the queue.
Yeah, given this discussion, I would like to recommend that we just go back to what we had before. Agency action in response to allegations of a violation, and then agency action in response to a violation. And that's basically on the principle of maybe let's not borrow trouble if we don't need to. So I think that was right, that conceptually both of those are within a process, and obviously at various points I can see we're using the term disciplinary process, but I don't think we need to say it in this heading. Because again, back to the point of, you know, it's not that the ABA will necessarily support this, but I don't think we want them opposing it. And there is something, I can see how they say, look, in the middle of a proceeding, you may need to sanction an attorney, but we're not sure that you should start engaging in start a reciprocal discipline piece. I mean, the other things we have here. So I guess I just want to speak to, I would like to recommend that we stick with what we had before. And one last point, I actually think there's a positive thing for agencies. Remember, we're trying to make this easy for agencies to implement. So we're saying, hey, agencies, think first about how you're going to respond to an allegation. Here are the things you need to have, the notice, the procedures. And now think about what you're going to do once you find a violation. So I would just stick with the headings we had as edited in a way that I think is helpful.
Thank you. Hi. Any response to that? Any objections to, I guess, reverting to the prior amendment of sort of dividing up the list into these two sort of temporal headings? Okay, seeing no hands. Let me let our scribe finish, and then I think we should scroll back up to the preamble and make sure. Let's do this. I don't want to get too in the weeds, but I think it might be helpful if we just went back up to the first paragraph and maybe just go paragraph by paragraph through the preamble to make sure that we've caught everyone's comments. Any further comments, suggested edits, concerns about the first paragraph in the preamble? And just as a heads up, toward the once we finish going through the preamble, we will go through the entire document. Don't want to belabor it, but we'll go paragraph by paragraph just to give everybody a last clear chance to weigh in. So just wanted to give everybody a heads up that was coming. But anything on the first paragraph of the preamble? I don't see any hands. Jeff, I think you're muted.
I'm going to make my comma point. Okay,
Okay.
on line 2, move the comma to after non-attorneys. In some programs, non-attorneys, comma.
Okay.
I disagree. I like the original spot with the comma.
I was afraid of that, Jeff.
Oh, we've got a comma battle.
A comma war.
Comma war.
There should be a pause after non-attorneys. The conduct of attorneys, and in some program, non-attorneys.
No.
Our dashes.
That's just the comma. You're putting the comma in the wrong place. You're changing the stress of the sentence.
I'm okay with
The
dashes.
the dependent clause here is in some programs. That's the clause that needs to be set off by commas.
Then you need another, then you need another comma after non-attorneys, which I don't really, so maybe use dashes. Okay, I'm done.
The question is whether who represent parties in adjudicative proceedings. Does it refer to non-attorneys only or to both attorneys and non-attorneys? If it refers only to the non-attorneys, then you don't have the comma. If it refers to both of them, then you need the comma, but it depends what.
Refers to both.
Yeah.
I
didn't
thought it
think
only
so.
refers to non-attorneys.
Me too. That's what I thought.
Yeah, I'm with Jack.
Do we need to say of attorneys and non-attorneys? I mean, do we need all that? Can we just say participation and conduct of those who represent parties? No?
I
You
think
just, like,
it's
isn't the whole world divided into attorneys and
But
non-attorneys?
we need to introduce the concepts here in the first paragraph, though.
I agree.
Okay.
The other possibility would be to just take out the in some programs clause altogether. Many agencies have adopted rules governing the participation and conduct of attorneys and non-attorneys who represent parties in adjudicative proceedings. The next sentence then makes the point that the rules address who can represent parties. So you could do it that way.
I think that works.
That's okay.
Speaking as a member of committee, I like that solution, especially given that this is the very first sentence and it's nice to have just a. That work for everyone? All right, further comments of this. Let's go on down to the second paragraph. Jeff. Jeff, you're muted.
Equally trivial, but he anticipated it and put it in there.
Okay, anything else on the second paragraph? All right, let's move on to the third as a general matter. All right, let's move on down to the next pair of agencies that adopt rules governing representatives. All right. Seeing no hands or furrowed brows. Moving on to once agencies have decided to adopt rules. And I think we've actually already devoted quite a bit of discussion to that paragraph. So let's move on to.
Russell Wheeler
Go
has
ahead.
a comment on this particular point.
I'm sorry, go ahead, Russell.
So on line 35, although it gets clarified, just the reader gets tripped up. Instead of do so, I would say enforce rules. Does do so refers to determine or does it refer to enforce? Just make clear agencies may enforce rules in various ways.
Mhm.
Speaking as a committee member, I think that's a really nice change.
Can I just interject? I don't like the up to phrase there because it seems like that's going to be disqualifying, is going to be the last, and then we go on for more. So I think we need to clean that up. Right.
I'm sorry, where?
In line 36.
Oh.
Mhm.
We got the word up.
So Jack, is your concern, are you just wanting to get rid of up, or is your concern sort of the having that as the sort of ultimate? I'm just trying to understand your.
I know, I mean, there's intermediate steps between warnings and disqualifying, aren't there?
Yes.
So like imposing costs or something, or, you know, they're imposing a monetary penalty. So ranging from,
Warnings
you know,
to disqualification.
maybe it's the including warning. It might, maybe it's just say including instead of ranging from. Maybe that would solve the problem.
Well, the
Including-
ranging
Including
makes it
warning
sound,
representatives that further misconduct be penalty to disqualifying, you know, including, and then comma, disqualifying a representative in the current or future, or imposing a monetary penalty or other sanction. Something like that. Just put commas instead of the twos.
I think you wanted, did you want including up instead of
No,
ranging?
Instead of ranging from, say including.
I think Bill was going to mention the same thing I'm thinking, that we wanted to identify that there is a range.
yeah, that was, yeah, I agree. I thought ranging from to was a good concept. That is, obviously a lot was left out in between, but the idea is that there is a range.
Mhm.
Maybe we could
Okay,
just say
go
more
back to the
serious.
original. I understand that, then go back to the original and just take out the word up, I guess.
Yeah.
This is high. I'm not, well, let's read it after you take it off. I was going to also speak to it, raise my hand to speak to saying, I'd like the ranging from for exactly that concept, right? I mean, force them in various ways, ranging from warning representatives that further misconduct may be penalized. I guess maybe not, but then it might be, the question is, if we're going to say ranging, then usually when you say ranging, even if you don't say up to, you sort of have this sort of sense of the last one is the most significant. So the only question is, do we think imposing a monetary penalty is less significant than disqualifying? In which case we would say ranging from warning representatives that further conduct may be penalized to imposing a monetary penalty or disqualifying a representative.
I have a suggestion for that. Maybe instead of penalize, maybe just say more serious sanctions, ranging from warning representative to more serious sanctions. And then, you know, monetary penalty is separate from that.
Right. Including at that point.
And then including at that point. I like that.
Can we
Emily,
add reminding or warning?
Excuse me, Emily, did you want to weigh in? Emily?
Yeah, I think there's a more fundamental awkwardness here, because it says ranging from warning representatives that further misconduct, and then we're treating the following language as if it's a list of things as opposed to a list of things that the warning might contain. So I think we need to clean this up more, like ranging from warnings to penalties to more serious sanctions, something like that, that doesn't embed what we're talking about in a warning.
I like that.
As a member of the committee, I like that too. So it'd be ranging from warnings
comma.
Yeah, the representatives that further misconduct may be should be deleted.
Yes.
Yeah, you said ranging from warnings to penalties. I
So
think
I don't think we need the
right to
comma.
monetary. I mean, I don't know. I mean,
Exactly.
Yeah.
No, just more from warnings to more serious sanctions.
Yes.
Yeah.
Yeah, so delete the comma after warnings.
Oops.
Yes.
To more serious sanctions.
Yes.
Comma including.
Yes.
All right, so I'm sorry, I have to use your last name to see if I got it right. Mr. Sakashevsky?
That's fine.
Oh.
Very good. I'm impressed. Thank you. So what I'm suggesting is that if this is the full range, at least in our agency, warning is not the first level, it's the second level. And there's a very specific distinction between a reminder, which generally can be done by the regional chief judge or the chief judge's office, as opposed to a warning, which can only come from the office of general counsel, which is a more serious level of the potentialities of sanctions. So I'm suggesting that we either say from reminders instead of warnings, or from reminders or warnings. Either of the two would work.
Speaking as a member of the committee, there's a nice parallelism there, ranging from reminders or warnings to more serious sanctions, including disqualification or imposing a monetary penalty.
Do we want to use the word sanctions here if we had had that previous discussion about sanctions versus discipline?
Speaking as a member of the committee, I'm fine with it there. I think it's clear
And
what we're
again,
talking about there. I don't know that we're.
I don't know that it's grammatically correct, because for a reminder or warning is not specifically a sanction. So I would suggest that instead of sanctions, we should say to more serious actions or something like that. We can incorporate both.
Thoughts on that?
Can you
More
repeat that?
serious actions.
Well, I think reminders are serious and warnings are serious.
Well, they're more serious if somebody is sanctioned. In other words, and again, I can't speak for all other agencies. In our agency, a reminder or a warning is not a sanction. This only sanction is an adversarial proceeding whereby a representative can be barred from practicing before the agency, either for a set number of years or forever. That's a sanction. So if you want to take away, or if you want to say other actions instead of serious, that's fine. But in my mind, there's a very concrete distinction between a warning or reminder on the one hand, or a disciplinary / sanction action, such as disqualification, or for those agencies that allow it, a monetary penalty.
Hi, did you want to weigh in on this?
Yeah, I just wanted to speak to the fact that I really like this sentence as it now is, for some of the reasons that have been said, but just to highlight. So we're telling them they have to determine how to enforce, may enforce rules in various ways. And then we really want to get the concept of the range. I like now adding ranging from reminders or warnings, because agencies can now learn from SSA. You know, you can even have something that's a reminder, and that is in itself an enforcement of the rules. And then I think saying two more serious actions is good. I think we need the more serious. And I like the idea of staying away from the term sanctions, again, on the principle of not borrowing trouble. For purposes of this, these are all actions, and whether an agency is going to call these actions sanctions or not, it's not really what we need to be conveying in this paragraph. So just want to speak to liking it as edited, because I think these edits are really quite good.
Right. On that note, anything else on this paragraph, or can we move? All right, let's move along. Scroll down, please. Agencies that have adopted rules. Anything on that? Nice short paragraph. Okay, moving on to this recommendation recognizes. Russell. Russell, you're muted.
Yeah, I
Thank
know.
you.
On 54, these aren't going to ensure those conditions, seeking to ensure. I mean, I do this all the time. I apologize. It seems to me it's naive to say that these rules are going to ensure these conditions, seeking to ensure, attempting to ensure anything but the flat ensuring, I think.
Okay. Bill,
A minor point, but on the same line, the very, very beginning of that line, it just read better to me to put in for FOR before non-attorneys. So it would read for agencies that decide to adopt rules for attorneys and if they elect to do so for non-attorneys. It just read better to me.
Jack.
Does anyone else share my sense that this paragraph belongs farther up in the preamble? That's my, I mean, I think it's a great paragraph, but maybe it belongs, you know, way up. I don't know. It seems like very introductory.
Further thoughts, comments, observations on that point?
Is that a question we could just refer to the Committee on Style?
Excellent. Sometimes I wish in my practice I had a committee on style that I could refer things to when we're going back and forth on a draft of a brief. Let's just refer that to the committee on style.
Delegation has efficiencies.
Touche, touche, Emily. Okay, anything further on this paragraph? Okay, moving down to although the recommendation does not, I think we need, does not endorse harmonization of rules for its own sake. Anything on the final paragraph in the preamble?
Does the last sentence belong in that paragraph? I realize it's only a single sentence, but I guess it does. I guess it does.
All right. Any further thoughts on the preamble before
I have
we
one
go ahead, Matt.
thought, Allison.
Yes.
I think this is an omission. I don't have the full document in front of me. If it is an omission, it's either inconsistent with ACUS practice and a grave injustice to George Cohen. I don't see his report cited anywhere in the, and I think given how little we pay him and how much he's done for us in a short amount of time, he's at least entitled to a citation. I mean, the Seventh Circuit got a citation from 1977. I would think George can get a citation at least as himself.
Speaking as a member of the committee, not a co-chair, I heartily endorse that. Which, and I'm sure it was an oversight. Sometimes it's the most obvious things that are the easiest to overlook, right?
Can we take a quick look at the headings one more time?
Sure.
I would raise the point that what Judge Sokojewski had said prior about warnings not being necessarily a response to a violation. Might be worth considering. He did have to step off though.
Come back.
Oh,
You need to move up to the allegations. I think.
I thought you were referring to paragraph 6 there.
So do you want to say alleged violation to be consistent with what you had earlier?
not in the heading, but I was simply suggesting that the committee may want to consider whether warnings or reminders are necessarily an action in response to a violation or an action in response to an alleged violation in this section.
I would think that here informal warnings would be a generic concept, not a formal quote unquote warning as defined by the agency. I mean, the warnings that were described are actually fairly formal if they have to be adopted by the general counsel's office as opposed to the ALJ. I think informal warnings as a phrase, informal warnings would cover any number of types of activities that are short of formal discipline.
But I guess the point is whether or not you'd only have a warning after a violation has been shown, proven, or whether you might want to have a warning or a reminder even before that. So do we need to add something about warnings and reminders in the previous list in number 5?
Kai, did you want to weigh in on this?
Yeah, I don't think even a reminder, which would be the smallest thing, should be done just based on an allegation. I think it's fine the way it's here. And I completely agree with the point of informal warnings. I think it's very different from what might be a formal. So again, maybe let's scroll up so we can see it to make sure that this makes sense. So you've got an allegation of a violation of a rule, so they should clearly indicate how, and maybe it's not going to say disciplinary, it might say should clearly indicate, the procedure for responding to an allegation of a violation of the rule. Among other topics, they should address who makes it, the notice, the procedures. So I don't think any of this, even the reminder, is part of the process, and maybe we want to not leave it to committee and style and decide what we want on line 118. So something along the lines of agencies should clearly indicate how they will respond to an allegation of a violation of rules, among other topics, and then take out disciplinary process works. Among other topics, agency rules. I don't know, do you want to use agency rules here? But anyway, among other topics, maybe agencies should address, because that's a little confusing, the rules. Agencies should address. And now here's all the things. I mean, you can say an agency should address or agencies should address. I don't think it matters. But you have to decide. So an agency should address, or agencies, I like the agencies should address. And again, what I like about this, thinking about in the implementation, this is a very nice checklist for agencies to look at as they're figuring out a process if they're now going for the first time to establish rules.
Thank you.
Should the first sentence, does anybody have any concerns or would prefer something other than the word indicate, especially given how High has rewritten the second sentence. Should it say agencies should address or state or something? I don't know. The word indicate to me is weak.
I like address.
Speaking as a member of the committee, I think address works very well there. And I share your concern about indicate.
Can I, we have
Yes,
address
Russell.
now twice here. Address is a kind of a weasel word. I would think specify anything, but two addresses. I mean, if somebody says address the issue of some, one more time, I'm going to scream.
What about the word determine? Because that's what we're telling them to do. Agencies should determine, take out clearly, how they will respond. And among other topics, they should address, which is where address.
Well, but I think the point is you're not just determine, you could determine it and never tell anybody. You want to state, people ought to be put on notice. They ought to know.
Oh, yeah. And I think we have that very clear. Let's see. Don't we have that under transparency?
Oh, yeah,
Would
that's in
would
transparency.
specify work instead for you?
Yeah.
It should be in their rules, shouldn't it?
I mean, that's the missing piece. If you're going to say specify, don't you need to indicate where they should do the specification?
In their rules.
Yeah, that works.
Yeah, but then you have rules twice. And they're, I think, somewhat slightly different, right? Right, the rules are because we're telling them, we think you should put this in actual rules, and as opposed to the violation of, oh, you could do conduct. In their rules, how they will respond to an allegation. No, we've used rules so much to cover all of this. I wouldn't take that out. Can you tell me why you think that the issue about letting people know what the process is isn't covered in transparency, as opposed to this recommendation, which is about, here's what you need to determine, here's what you need to decide? Just explain that. And maybe, yes, scroll down to transparency and let us see whether that addresses the concern that was raised.
A suggestion as a member of the committee, should 9 be the first? What's 9 be the first? Or should what's currently 10? Just seems like 9 seems like a more specific point that doesn't really make the kind of more general transparency point that I think we're looking for.
The switch 9 and 10.
Yep.
Yeah.
Yep.
If you can go back up to the one we were talking about before, maybe at the beginning, among other topics, agencies' rules should address. And then we can get rid of some of the rules in the previous part.
So it now read, agencies should specify how they will respond to an allegation of a violation of rules.
Conduct rules?
Of their rules?
the first sentence, the usage of rule here is the substantive conduct rule, but then the second sentence, the use of rule here is more the procedural rules that are the subject of this paragraph, which may lead to confusion.
I see.
Isn't it important, I'll just make this point one more time. Isn't it important to make clear where these things should reside, namely in rules, as opposed to in some other place?
So it says agencies' rules should address.
Yeah, but it first says agency should specify. Shouldn't there be a reference to rules there? I understand there's a kind of a verbal concern about using rules twice, but it seems to me like if you're going to indicate that they should specify, you should indicate where they should specify. I'll drop it at this point.
I think it's a good point.
Same.
In their rule, could we cross-reference the transparency provision there? Then you can probably take out the reference in the among other topics sentence.
Mm-hmm.
Agency should address, or I think that meets Matt's point better.
Matt?
Yeah, absolutely.
Okay, anything more on this?
But this is high. I really like how that's changed, although don't you need a there in front of conduct rules? Should specify in their rules,
Yes.
consistent with transparency, allegation or violation of their conduct rules. As opposed to conduct rules generally.
Yes. All right, given that we are almost at noon, I would propose that we take a short break and then we can come back and do our sort of final walkthrough, final comments. Gavin, Reeve, Matt, does that make sense?
That sounds great.
Okay.
Perfectly.
All right, so let's take about, what's customary, 5 minutes? 5 minutes work?
Yeah, I'd say 5 minutes, maybe reconvene just right after noon.
All right. All right, well, we'll pause for a break and then reconvene shortly after noon. All right, that's a good cue. We will reconvene, and once you get the screen up, I believe we had wrapped up our discussion on this and we can proceed to just sort of going through the document as a whole to capture any other thoughts or edits. Let's go ahead and scroll up. We, having just spent time on the preamble, I don't think we need to spend a great deal, but I do want to give people, especially since today was the first time that we discussed it.
I had one suggestion on the
Yes,
preamble.
Yes, Carrie.
Going back up to the 5th paragraph, it starts with once agencies have decided. In keeping with Kai's recommendation that we not borrow trouble, I was thinking maybe on the last sentence, agencies also must decide whether to implement a program for reciprocal discipline, which involves agencies imposing discipline. Perhaps we could change that to sanctions, agencies imposing sanctions. Later, we do talk about referring to another jurisdiction for purposes of taking disciplinary action. So if that doesn't change our intent, maybe it would be better to say sanctions there just to keep clear what we discussed earlier, the language that's recognized by the ABA, the distinction between sanctions and discipline, just to not borrow trouble.
I think there's a I think there's a problem there because a sanction would only be for particular actions, way the ABA uses it. So, but this is actually imposing discipline because of what somebody else has done, and the ABA supports that. ABA supports reciprocal discipline situations. So I think leaving discipline here is the appropriate word rather than sanction.
Because it's more, it encompasses more activity than just sanctions. Okay.
Correct.
Okay, I withdraw my suggestion then.
Thank you. Thank you, Bill and Carrie.
This is Jeff. I still want to go back to determine on 39 rather than decide.
I don't see the difference, but I don't care.
I'm fine with it.
Yeah. Thank you, Jeff. Any further revisions, thoughts to the preamble? Russell?
I do on line, I think it's 66. Oh, no, I think a little further down. It was 66, yeah. To adopt or refer to rules, that replaced in the November 5th version, incorporate by reference, refer to, replaced, incorporate by reference. Was that the drafter's intention, that refer to is the same as incorporate by reference, or do they wish to say something different?
I think our intent, Russell, was to try to get away from the use of the term incorporate by reference. So we intended adopt or refer to be broad enough to encompass sort of the full range of activities they may undertake.
I don't want to push the point, but just refer to, I mean, the common sense common sense understanding is it makes some allusion to, or some nod towards. If everybody's happy with it, I don't want to push the point.
But just say reference, adopt a reference.
Well, that would get, yeah.
Reeve, thoughts on that?
That's fine. I mean, I'm not really usually a fan of sort of using nouns as verbs, but I think that's fine. I think that encompasses the point. So I don't have any objection to that.
Okay, did anybody have anything on, I'm gonna reference I'm going to refer to the headings and moving through the rest of the document. So now that we're in the recommendation, adoption of rules governing participation and conduct, anything on that paragraph? Okay, anything further on rules of conduct? Agencies should consider possible topics. I know that we've spent some time on those, but I do want to give folks an opportunity to make further comments or revisions if necessary. Can we scroll down a little bit? Thank you. Okay, paragraph 4 of that section, agencies should consider whether divergence among. Okay, moving on. Agency action in response to allegations of a violation of rules. Anything further on? I think now we go down to 5. What's now 5? Our list. Okay. Agency action in response to a violation of rules. Okay, please scroll on down. Who can practice before agencies?
So if someone was convicted of a crime and it came to the attention of the agency, would that be a violation of the agency's rules? I mean, if the rules said you couldn't practice if you were convicted of a crime, I guess it would, but. Or I guess my question is, are all the things we're talking about here allegations of violations of rules? Are there other improper behaviors that agencies might want to impose, sanctions for? Or
Just to answer that point in part, we do have in the substantive rules section as part of the topics that agency might consider is knowingly disobeying or attempting to disobey agency rules, including the conduct rules. So it's rules broader, but it does not include per se crime, although that's included in K.
Yes.
Yeah.
Yeah, I think that's the idea, is that K, the agency should set forth in rules if a violation of a crime would be, something that they would sanction or, take action against. So it should be in the rules, but it's, it's provided for in number 3.
Okay, I'm really just worried about the headings.
Well, wouldn't it then be a violation of the rules? Wouldn't it then be a violation of 3K as we've specified it above?
Yeah, if they put it in their rules.
Yes. So Jeff, does that address your
I guess
concern?
it just seems like there's a slight disconnect, but only because we're trying to be so pithy in our headings here.
Yeah. Okay, anything on who can practice before agencies? Transparency.
How about number 10? I mean, this is Emily's bailiwick here, but if the rules are copyrighted, how can the agency ensure that the rules are available to the public at no cost? This is the whole issue that we took up in our incorporation by reference recommendation, but an agency, yeah.
Are any of these rules copyrighted? I mean, are we addressing an academic point here?
Now, the ABA representative in our last meeting confirmed that the ABA rules are copyrighted.
But I thought the ABA representative also said that they are available, freely available on the ABA's website. No?
She said they were public. They said they were publicly available.
I think somebody said that you get around that by finding the way that the ABA rules as they're adopted by a state and published.
No,
That's what I said. That's what I said. But the ABA representative said that they are publicly available. I didn't remember how they were. Maybe Larson has the answer. I don't know.
Yeah, the answer is because I refer to them all the time myself when we refer to them in our letters to Congress or to comments to federal agencies, is although they are copyrighted and you have to pay money to get a bound copy of them, they are available on the ABA website. If you go to the ABA website and I can find the link and send it to Gavin or Matt to circulate, but if you go to I think it's what the quote table of contents for the model rules professional conduct, it actually lists, if you click on that or click on each of the links for the rules in the table of contents, it goes to the actual rule and the complete comments. So it is publicly available on the ABA website. You can read any rule and all the comments in their most current version just by linking to the website.
It's kind of also unimaginable that the ABA, or if there are any other organizations that promulgate model rules, and I don't think there are, it's kind of unimaginable that they wouldn't make these kind of rules publicly available for free on their websites, unlike a copyrighted standard or something.
Yeah, I mean,
hard for me to imagine.
I'm not in charge of that, but I would agree that it would be in the ABA's interest to make them, readily available, because to the extent that the ABA would like them to be followed and would like to have things not conflict with them, I agree that would make sense. But I'm not sure, to what I know the ABA, like I said, charges for bound copies, but it also makes the full text available on the website for free.
So are we raising issues here that we don't need to raise? And can we?
I think the way it's written is fine. I mean, it's absolutely accurate. They are, if they did promulgate ABA model rules, they are copyrighted, but the agency can ensure they're available to the public at no cost by referencing the ABA website.
Why do we need
providing a link to that page of the website? Because the ABA website has an enormous amount of content on it, but if you have the link to that particular web page, which I can send to Gavin and Matt just for you to circulate, then yeah, that would be a very low cost way to make that available easily.
Yeah, the current language that we have there takes care of it perfectly.
Yes.
Do you want the language which in some instances may be copyrighted? I mean,
I don't think so.
I think so, because if anybody had any questions, somebody might say, well, aren't the ABA things copyrighted? And somebody will say, yeah, they are. And that'll raise those sorts of issues. But I think we need to, this makes clear that the ABA rules can be one of the rules that you can adopt.
I think this adequately flags the issue for agencies so that they're aware of it, and makes clear that we're aware of this possibility and we don't care. It's not a reason not to make sure that these things are available.
Yeah, and if you have to pay for them, then you have to pay for them. I mean, the agency, to put them up, it's just, you got to make them available. It's just, there's no compromise here. That's why I think this is, and I think the analysis here is frankly a little bit different than the earlier recommendation.
I receive.
Okay. Anything else on this paragraph? Okay, 11 or 12. $13. $14. Going.
I would raise one suggestion that the committee consider whether or not the reference that they've now inserted in the prior paragraph does the work here that they intend. So agencies should specify in their rules how they'll respond to an allegation of the violation of their conduct rules. And we say consistent with the transparency paragraph. So I just want to make sure that that reference does the work the committee intends it to.
Paragraphs.
Yes.
Would it be all paragraphs or paragraphs? It's at least paragraph 11 and 12.
Kevin, perhaps this is a committee on style thing. We
Fair,
can work
fair.
out later.
Yeah.
Yes,
Hold on.
the Committee on Style. Thank you, Reeve. What would we do without it? I don't want to even ponder it. All right. Model rules. Anything more on 15? Right. Anything more generally?
So thank you for including the ABA in the end of your thing there. Can I ask a question? I don't want to interfere with your proceedings here, but before you finish up, can I ask a question about the harmonization part of the recommendations?
Certainly.
Because again, I'm in a difficult position because we have our current policy, but in terms of trying to ensure that this is as consistent with or not in conflict with the ABA position as possible to maximize the chances the ABA might eventually endorse it or at least not oppose it. One of our big concerns, of course, in all of our dealings with federal agencies is trying to ensure that federal agency rules do not. Our first position, of course, is that courts and their state disciplinary agencies should be the primary disciplinary entities for lawyers, as I explained before. But the other thing that we get involved in most frequently is objecting when agency proposed rules or existing rules conflict with the ABA model rules of professional conduct, which are then generally adopted by state Supreme Courts as binding rules. Because our concern is creating conflicting rules, which would undermine the authority of the courts. Are you at the top of the harmonization part of the recommendations here? I'm curious whether any of the recommendations here, which I didn't have a chance to read as I was scrolling down, say something like, agencies should consider whether their rules are consistent with or do not conflict with binding state disciplinary authority rules to which attorneys are subject, or something like that, in order to kind of convey the idea that although these recommendations obviously are encouraging agencies to consider many options, one, thing to keep in mind is there's some value in considering whether their rules would be consistent with, or at least not in conflict with, the state court disciplinary rules to which attorneys are subject.
Kai, did you want to weigh in on this? I see your hand is up. I'm not sure if you had a previous point or if you want to be heard on this.
So I had a previous point for the last paragraph, so I'll also say that. But on this, I get the point. I totally get the point. I think it's going to be a little difficult to say to agencies before you do your rules or after you do it, to then go look at every state, attorney disciplinary process. I think that's going to be difficult. So I don't think that doesn't make sense. And, but I think that's a big deal. I guess I'm saying, I think that's a big deal to add to the recommendations now. And I'd love for there to be some other way of sort of communicating that to the agencies, but I don't think it makes sense to actually add that as something we would want and expect agencies to do. Although I really, really understand the instinct behind the recommendation.
And
Larson, how would you harmonize, how would you ensure that agency rules are not inconsistent with rules of conduct, which themselves vary from state to state on particular points, which I assume is why you have conflict of laws issues that come up?
Well, that raises a real issue and complication, I agree. And although it's true that the state Supreme Courts do adopt rules that vary from the ABA model rules, the most important rules, in my understanding, in working on this issue and dealing with and talking to Ellen and Mary from our Center for Professional Responsibility, is with many of the most fundamental rules, the jurisdictions adopt them almost uniformly. For example, Rule 1.6 on client confidentiality, all of the jurisdictions adopt something very close to that with minor variations. And there are other rules that tend to be adopted very closely and consistently. I agree that it's a difficult, you don't want to put unreasonable burdens on the agencies and suggest something they're never going to do by making it too complicated for them. But perhaps if it could be stated in a more general way that wouldn't suggest they would have to go pick through the individual rules adopted by all 50 state Supreme Courts, but rather perhaps ensure that they're not inconsistent with maybe generally accepted model rules or something else that would make it a more reasonable suggestion. I'm not exactly sure how to wordsmith that, but there is value to that, and because otherwise it puts the attorney in a very difficult position if there are two different standards, one for which they can be disbarred if they don't follow it, and the other for which they can be, disbarred, or whatever the term is, not permitted to practice before the agency anymore. That puts the attorney in an impossible position. And that's one of the reasons why we objected to that SEC proposed rule that I mentioned back in the early 2000s, where they contemplated adopting a noisy withdrawal rule for lawyers for companies that report misconduct up the corporate ladder and are not able to fix the problem. And the SEC would have required lawyers to adopt this rule that was in conflict with the ABA model rules. And they ultimately dropped that proposal when we tightened up our own model rules on that issue.
I'd see that, Kai, I know your hand is up again and Emily's hand is up. Kai, I didn't know if this was about the previous paragraph, your hand is up, or if you want to engage again on this issue. So Kai, go ahead, and if you want to engage on this issue, and then Emily, you're next in the queue.
Yeah, I do want to engage again on this issue. I guess what I'm thinking is, at least what I would be looking for from the ABA is not necessarily endorsement of this, given sort of the position the ABA is in, at least at the moment, but certainly not opposition. So I'm sort of looking at it through that lens. So I'm glad, I think Lawson, you get that we don't want to say something that agencies aren't going to do. But I think for your concern, I would be surprised if they would actually adopt a rule that would put an attorney into a difficult position if it actually conflicts. I mean, I think an agency would want to know that. So there's a whole process that they're using here. So I get that concern, but well, no, I don't get the concern as much because I don't really think that will happen as a practical matter. And I think that the difficulty of trying to say something directly outweighs the need to address that particular situation.
Emily? Oh, I'm sorry. I didn't mean to.
No. I'm just going to keep my hand up just for the other
For the
point.
next one. Okay. Emily?
Yeah,
In the
I mean,
bill.
I can appreciate the concerns. I just, I think the recommendation as a whole, like, I mean, we can look at a sentence here or there, but I think the recommendation as a whole is operating on the premise that we understand that attorneys are regulated by a variety of jurisdictions, and agencies can't, I mean, they need to be able to control the conduct of people who are appearing in their proceedings. That I think is a fundamental point that we can't, I mean, if the ABA doesn't sort of agree with that, I don't think we can actually sort of address that really fundamental conflict. And I think the recommendation is well designed to encourage agencies to use existing rules to harmonize to the extent that's possible, and not to impose a whole bunch of like random, I mean, I just think these concerns are already integrated into the document as a whole. And so I guess at this point, we're at the end of our third meeting. I think the prospect of trying to on the fly wordsmith something that captures a principle that to my mind is integrated throughout the entire recommendation seems unnecessary at this stage, especially without any proposed language that we could really be focusing on.
I appreciate that, and I know it's difficult. So let me ask you this. This may or may not help.
Could I speak, Larson, on this? I mean, I understand we are at the late stages, but I have a sentence that I think might do it. Agencies should attempt to avoid requiring conduct that would, attempt to avoid a conduct rule that would require an attorney to violate the rules of conduct applicable to the lawyer in his state. That's the idea.
Kai,
So
did you want to be
wanna
heard?
use- Oh, go ahead. I'm sorry.
Kai?
I just think that's a problematic statement for a few reasons. I mean, attempt to avoid a conduct rule I don't think they should have a conduct rule that would require the attorney to violate the applicable rules of conduct in the attorney's state. So I don't think they should have that. And just as a practical matter, if you look above at all the things that you want the agency to say, sorry, you can't act this way in our processes. Why would that ever, I mean, this was back to my sense comment to Larson, why would that ever result in violating the rules of conduct in the attorney's state? It may not be framed in the same way, but I guess I want to sort of align myself with Emily's point of, I feel this is in the whole gestalt of the preamble recommendations, and I'd be really wary of trying to craft another sentence now.
If I could just speak for a second on that, which is that there is at least one or two examples, one the SEC example, one an FTC example, in what agencies did would almost clearly violate a state rule of conduct. Now, those were specific one-time rules that they were trying to adopt, rule of conduct, but it was nevertheless, it's something that whether it's attempt to avoid or should avoid, I could live with should avoid too, but it's entirely possible that an agency might actually do that. And I think, it's worth saying you shouldn't do that.
Yeah, I think something like what Bill suggested would be helpful. I don't know if it's practical to do it, but I think it would be worth exploring. The other thing is if it would be helpful, although many people talk about, oh, lawyers, want to be self-regulated and regulated by the bar, we don't really view it that way. We view it as lawyers being regulated by the courts. And so to the extent that these lawyer disciplinary rules are court rules, they're adopted by the state Supreme Courts in which the lawyers practice are licensed or are permitted to practice, and the bars act merely as agencies of the state Supreme Court, to the extent that it could be perhaps worded as ethical rules adopted by the applicable courts, licensing the attorney or something like that. Perhaps that would be more palatable if it's a matter of urging the agencies to be sensitive to not requiring conduct that would be in violation of court disciplinary rules as opposed to, the bar's own rules.
George, I thought I saw your hand up. I wanted to give you an opportunity to speak.
Yes, well, I mean, so I don't think it's a good idea to include this in there for several reasons. So first of all, the ABA model rules themselves incorporate tribunal rules, which in my view include agency rules. So it's you have an obligation, an ethical obligation, to follow the rules of a federal agency acting in an adjudicative capacity according to the ABA's own rules. In addition, the ABA's rules have created exceptions for the duty of confidentiality, including for compliance with other law or court order. And so I really don't think that there is a conflict. I don't think there was a conflict with the noisy withdrawal rule, but I don't want to get sidetracked on that issue because it's not an issue here. So, but I think it's I think under the supremacy clause, and I think that the ABA's own rules, the agencies have right to do this. And I don't think it's going to happen that there's going to be something that's going to be a conflict the way that's being suggested.
If I can respond to George, I'm not suggesting the ABA's model rules would ever create a problem here. That's why it's the rules of conduct in the attorney's state, because the states do differ from the ABA model rules. So that it's not clear to me that, I mean, I agree with you that they couldn't ever violate the ABA model rules the way that's phrased now. And I understand the desire not to add something into the recommendation like this. I could live with putting it in the preamble as a sort of an expectation it's implicit in the recommendations that there would be no such violation like this. And if that would make people happier, I could certainly live with that.
Also, I wanted to distinguish between that point on whether the ABA has incorporated the tribunal's rules. I think that's an overstatement of what the ABA model rules say. The ABA model rules say that lawyers are required to follow them. That doesn't mean that the ABA supports the agency rules, just that the ABA says that lawyers need to follow the law. You kind of, similar in some ways to the permissive disclosure of client confidences under one of the exceptions of Rule 1.6, where it says if required by law or court order, lawyers are permitted to disclose confidential client information. It doesn't mean we think it's a good idea for there to be laws to that effect. And we regularly lobby against those proposed laws. But I think what the rules say is that when a law or a tribunal's rule has been adopted, lawyers are obligated to follow them, but that's not to say the ABA supports them. And that is a distinction, because that frees us to challenge them whenever they're being proposed. So, we're currently challenging a number of federal agency proposals that if adopted, our members would have to follow, but we don't think they ought to be adopted. And for example, the Labor Department's persuader rule that would require management side labor lawyers to disclose client confidences to the Labor Department. We fought that tooth and nail, and the Fifth and the federal court enjoined that Labor Department rule under the Obama administration, and then the Trump Labor Department rescinded the rule. So if that rule would have been adopted, of course, we would have followed it, but we vigorously oppose the proposal of that rule.
If I
Go
could-
ahead, Kai.
And so I appreciate, Bill, the idea of putting this into the preamble as opposed to here. I certainly could support something like that, the concept there. I would want it to be written in a way that we're not having an expectation that the agency, before it feels it can do this, is literally going to review all the cases in every state. But it might be that someone would bring that to their attention, in which case, you know, they should attempt to avoid such a rule. So I just want to say, I would like to see it out of lines 103 to 104, and maybe something in the preamble that makes what Emily and I were saying we thought is the whole premise of this, to make it a bit more explicit. Again, I don't think that's going to get the ABA's endorsement, and I don't expect it to, but it may show some accommodation. And I know this is not in correct order, but I have to jump off for something else. So if I can just, well, let me not, let's finish this. My other thing felt important, which I'm not sure why it says in the last recommendation that it's only model rules for paragraph 3, as opposed to model rules for implementing, should consider promulgating model rules of conduct that would address the topics in these recommendations. Right? I mean, there are a lot of other things here that are really good ideas, but it'll be helpful to give agencies some concrete ways of doing it. So unless there was a reason that I didn't know.
And let's not forget, Larson, also that the ABA will have a seat at the table in terms of ACUS's drafting of model rules per this paragraph.
Yeah, we appreciate that very much. And let me just add one, brief comment on that. As I explained in my initial statement in the first meeting about the ABA's current policy adopted in 1982, which still remains ABA policy, even though events have somewhat overtaken the ABA's position. If you recall, that policy was the ABA believes that federal agent, supports legislation to prevent federal agencies from adopting their own rules of procedure, except as immediately necessary to control the conduct in a proceeding. The circumstances for the ABA adopting that policy in 1982 was it was chosen over an alternative proposed by the ABA Committee on Professional, whatever it was called at the time. It's currently called the Committee on Professional Regulation, that would have endorsed a federal model rules of agency disciplinary procedures. So that was rejected back in 1982. Now that the agencies have all adopted their own rules, or most of them, I think that there's some chance the ABA would consider an updated version of that proposal, particularly if it was headed up by ACUS, which is sensitive to many of these issues that lawyers are sensitive to. So we greatly appreciate being invited to participate, perhaps through our administrative law section, which has the most expertise in the ABA on these issues. And it's very possible that the ABA would reconsider. I can't speak for the ABA on that because it's not my role to make ABA policy, just to try to implement it. But it's very possible that if that were a proposal, it would be seriously considered by, the ABA policymakers.
Bill, I see your hand is up.
Yeah, I wanted to thank Jai for her, willingness to accept something like my language in the preamble. And as I said, I could certainly live with that, because I think one could say that it's implicit in the recommendations as a whole. She said as a premise of, or she and Emily said premise, but I'd say it's implicit in what we're recommending, that attorneys will not be put in the position of having to violate one rule or another. And I would leave to the Committee on Style to put in a sentence somewhere in the preamble to that effect. I trust them in that regard.
So
Well, just a
go
quick,
ahead, Matt. Go ahead, Matt.
just a little quibble here, just in terms of the language. Assuming that the committee agrees to do that, I might suggest that rather than saying violate the rules of conduct, act sort of inconsistently with the rules of conduct. Violates kind of a legal conclusion, and it may not be, given preemption rules, it may not be a violation. I don't know. It's really more of a question than a.
I'm fine. As I say, I leave to the Committee on Style. It's the concept that I think is important to get into the preamble.
So I think this is one of those moments, to quote Aaron Nielsen, where I wish we were in a room together, because I think it would be easier to get a sense of the room on this point. If I could ask for Gavin's assistance, it seems to me that where things stand is the question is, does the committee want to include something massaged by the Committee on Style along the lines of this sentence in the preamble or not? Could I get, and Reeve, Gavin, you may want to help me on this. I think it would just be helpful to do a straw poll, show of hands, whatever, just to help us get a sense of the committee on whether the committee wants something along these lines in the preamble. I think what's before us is in the preamble or not, as opposed to the preamble or in paragraph 4. But if I'm wrong on that, let me know. I think the question before us is, do we want to say something along these lines in the preamble or not at all? Matt, did you want to?
I can briefly say that's my sense as well of where the committee currently stands. And I think, yeah, you could maybe, you could either ask, does the committee have any objection to doing that?
Okay, thank you, Reeve. I'll frame it that way. Does the committee have an objection to including a sentence along these lines as massaged by the Committee on Style in the preamble?
Fine with me.
Fine with me as well.
Fine with me.
No objection.
Same.
Agree.
Hey, can I just add one technical suggestion there? And I wish Ellen was in here, but based on my earlier conversations with our experts from the Center for Professional Responsibility, you might want to consider fine tuning the very end of that sentence as you massage your own language. You have to say something like, in the state in which the attorney is licensed or otherwise authorized to practice. Because attorney state is a little bit ambiguous. And when I've dealt with Ellen and her people on fine tuning our letters to the Hill and the federal agencies, those kinds of edits have been suggested, and we usually take them. And so that might cover the idea a little bit more precisely, but the exact same idea that you're talking about.
The Agency Practice Act has its language that you could pick up as to where the attorney is licensed.
But my concern is whatever the rules that the agency is going to pick is going to be universal. It can't apply to only some attorneys, depending on what their state bar requires, and not to others. So we have to be very careful about that, because there's only going to be one rule that applies to all attorneys. So hypothetically, if there's one state that it would be in conflict, then that would mean that need to change it for all states, not just for the attorneys in that state. And also there's a typo in this proposed sentence. I think you forgot it too, require an attorney to act inconsistently.
Well, that's.
And that authorized to practice, authorized or admitted to practice, whatever the term would be, would cover situations where an attorney was appearing in a case pro hoc vice, or however you pronounce that, where the attorney has gotten permission to appear in a court in a state in which the attorney is not licensed, but has authority to practice for the purpose of a case. So that would be an example of a state where they're not licensed, but where they're authorized to practice.
Speaking as a member of the committee, I do wonder if everything that we're talking about is just sort of included with applicable rules. to act inconsistently with applicable rules. Whether it might be better just to, especially since we're framing this in terms of what we're asking agencies to consider and avoid.
Well, the remainder of the sentence does add clarity to sort of what's envisioned, but so there would be some value in that, but.
I mean, the point, and it's against Mr. Sakashevsky's point, which is we're not trying to say that it has to be the same rule, right? It's just that the attorney shouldn't be put in the position of having to violate one rule or the other when he practices somewhere for some agency, and we should avoid that to the extent absolutely possible. And therefore, it has to be the rule applicable to the attorney in the state in which he's licensed. Now, as I say, go to the Agency Practice Act. I don't have it right in front of me, but that has the statutory basis upon which lawyers can appear before federal agencies, and it specifies the practice, where you're authorized or how the phraseology for that. And yeah, and we took out in violation of it because Matt didn't like it because it sounded really bad, and inconsistent might be too weak. We want sort of contravenes as, incompatible. How about incompatible with that rules of conduct? The idea is it's an extreme situation. It's not likely to happen. And we presume that the whole premise of this thing and the implicit in these rules that we're recommending that this wouldn't happen. That's why we're saying it in the preamble, not as a recommendation.
Bill, I also liked your inclusion of language regarding, and I don't want to pile on and further belabor, but to the extent practicable, or as the Committee on Style thinks through this language, I think that would be.
Yeah, in contravention, I think might be a way that's not violation, but at the same time, not just a weak.
George, I see. George, I see your hand is up. I'm sorry, Matt, go ahead.
Well, just in terms of the drafting of this, and I just want to make sure the committee's got this expectation. This is cast in terms of a recommendation, which we don't normally do in the preambles, and somebody is probably going to object to it. It could be written in a way that's probably less recommendation, like you could say something like, in promulgating these recommendations, ACUS that ACUS expects or something like that agencies won't do as follows. But if it's cast in recommendation language, somebody at the plenary session is going to object, and we're going to end up either redrafting it or moving it into the recommendations.
And I agree with what Matt's saying there. I phrased it, my phraseology, to suggest that the style people is to say implicit in the recommendations is an understanding that.
Then it sounds like we're all on the same page here.
Yes. George, I see your hand.
Yeah, I just wanted to make 2 points. So one, on this idea of stating the state where the attorney is licensed, that's not the rule in the ABA choice of law rule. When you're practicing before a tribunal, the applicable ethics rules are the rules in which the jurisdiction in which the tribunal sits. And so if you wanted to be consistent with that rule, which not all states have adopted, that would be the choice of law provision there. But so that's the first point. The second point is, this question about what you mean by contradict or in contravention of. So just to give one example, we discussed at one of the other meetings this question of knowingly making a misrepresentation to a tribunal. And there was the point made that, well, some of the agencies adopt a lesser standard than knowingly, such as recklessly, which the ABA is somewhat ambiguous about. And so would that be inconsistent if the ABA had a lower standard of misrepresentation to a tribunal? Would that be in tension with, so I think you want to be careful about what you say there.
Thank you, George. Anything further on this point? George, I see your hand is still up. Did you have something more? Okay. Okay.
Point of order, does the committee prefer location of tribunal per George's recent comment, or where the attorney is licensed or authorized to practice? Those would be two different inconsistent standards.
Where the attorney's licensed or authorized to practice. In appearing before a federal agency, they can be licensed anywhere.
Emily?
Rest assured, Allison, this is going to get worked over at the plenary session. So
Oh, yeah.
you may not want to sweat this one too much.
I was just going to suggest that maybe if we move it where we have all that list of, agencies must, maybe this is another agencies must, agencies must be sensitive to blah, 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 blah. I'm also not going to wordsmith it, but I think maybe finding a location for it might make the phrasing come more readily.
I'm afraid that all the musts in the preamble relate back to things in the recommendations. And here we're adding something that isn't in a recommendation, don't want to make it look like a recommendation. So that's the only reason I'd be wary of the must.
You could use the passive voice. This requires sensitivity too.
When we're resorting to the passive voice that
I'm frankly ready to abandon the whole paragraph. As an agency representative, I can tell you that in reading that paragraph, I'm going to be like, I'm not looking up every state's model rules. And we do have attorneys from all states who appear before our agency. So it doesn't really seem helpful to me as an agency representative. I don't know if anybody else feels that way, but
I mean, I agree that this shouldn't be required to look up everything. But the question is, what happens if somebody raises the issue? And somebody says, well, gee, that rule would put me between a rock and a hard place. I can't follow both the rules of my state or the rules of your tribunal. I have to violate one or the other. And if an agency is
I just want to say this is a long-standing issue that has to do even with federal court rules and state conduct rules, and I don't think we're going to be able to resolve this or even come up with wording that's going to avoid these questions. So I'm leaning towards agreeing with Carrie that we should just cut this issue out of it altogether. And then if it comes up at the plenary, I think we can say that this is just. It's an issue. It's a vexing issue, even with regard to courts, federal versus state courts. And we just didn't feel that, there was anything we could add to this that would be productive.
I think Jack is right in that this is not going to prevent it from happening. So why buy trouble now?
And let me just add, as someone who
go ahead.
As someone who presides over sanction hearings, if that would be, and it's never happened, if that would be a defense that the representative would give, I would give it, a lot of credence. And, it's not as if we're going to ignore it, but it's not something that happens a lot. When it does happen, any adjudicator exercising common sense is going to at least consider it.
Agreed.
Are we talking about two different things here, though? One is drafting the rules to avoid inconsistencies. Another is in individual application, potentially giving a dispensation for a particular representative. Are we talking about the same thing here, all of us?
Well, my concern, if you're drafting it, that means something is first of all, is a problem that we have to recognize as a problem and that may need some consideration. And very much, like Harry said, I said earlier, I can guarantee you most agencies are not going to look up every state rule to see if there's a potential violation. So when is it going to come up? Only if a representative says something. When is a representative going to say something? Only if it's a particular issue.
The reason I draw the distinction is this particular language refers to promulgating rules and not dealing with the issue at the point of application.
Right,
to
but
a
my
particular
concern is,
representative.
no, I appreciate that distinction, but in order to promulgate the rule, then essentially the agency, when it drafts its particular rules of conduct, in theory, is going to have to look at every single state. That's not going to happen.
Well, it wouldn't have to do that because as I said before, the binding state courts in general closely track the ABA model rules. And so if it's not an absolute requirement, but simply an area in which they should be somewhat sensitive to avoiding direct conflicts with major ethics rules, you know, an agency person writing a draft agency rule could do that pretty simply by looking at the model rule and declining to propose a rule that's in direct conflict with a major model rule, 90% of which of the states adopt.
Excuse me, Michael, I see your hand up, Michael.
Yeah, sure. I would personally be in favor of keeping some form of this language because this very issue came before our agency when we were promulgating our own disciplinary conduct rules. Namely, what we ended up doing in our proposed rule that we have out there is that we apply the ABA model rules of conduct basically incorporating them into the standards that would apply for discipline to representatives that appear before us. But we only apply the ABA model rules as practicable because we envision situations where there could be potential conflict with state rules where attorneys are licensed to practice. So we wanted to have a little bit of wiggle room with a feasibility, practicability standard in application for any alleged violation of conduct in a specific setting where we're kind of determining what standard applies to avoid any conflict. So this very issue came before us. So I think it's very relevant. I think it could be helpful to have some form of language in there just to kind of, give a heads up for other agencies who may encounter the same issue. So I personally would be in favor of retaining some form of the language, leaving it to the Committee on Style to kind of hammer out the details of how to draft it. But I personally like the language, but that's just me.
Bill?
Yeah, I mean, I never wanted in promulgating the recommendations, conference expected it. That's so, I don't want to tell anybody they have to do something. The idea is that implicit in what we are recommending is the understanding that an attorney won't be put in the position of having to act in contravention of the rules under which the state in which he's licensed to practice. It's not a recommendation. It's something that's just implicit in everything we're saying here. And it's a heads up, and it's not recommendatory, and it doesn't require anybody to have to go and search out what every state's rules are.
Michael, did you have more to add?
I just was going to say I agree with what Bill said on that front.
That language would be a lot better.
So Carrie, are you comfortable with moving forward with this, having something along these lines in the preamble now?
The implicit. So, yeah, I don't remember Bill's exact wording, but I thought it was a lot better than what's on the screen right now.
I'd say implicit in these recommendations is the understanding that an attorney will not be placed in a position in which the attorney must violate the rules of conduct of the state in which he's licensed to practice. And I leave that to the Committee on Style, but that's the idea that it's not a recommendation that we're making. It's an understanding that this is something that won't, Matt didn't like violate, so must act in contravention.
Carrie, are you comfortable
Yes.
with that now?
Yeah.
So we'll be able to say licensed licensed or authorized to practice.
Fine, fine.
Well, that would be, I mean, that would be helpful, I think, from the ABA's perspective. I mean, that would be helpful.
Anything further on this? I know that we're past time. I think this has been an important discussion to have. I don't want to cut it short, but I also want to be respectful of everyone's time. All right. So now that we have gone through all this, is there any, and I've seen some folks already weighing in on this on the chat who had to leave. Is there any objection to adopting the recommendation as it now stands, subject to the non-substantive work by the Committee on Style?
Allison,
Matt, go ahead.
Somebody's going to kill me on the ACA staff for asking this question, but I'm going to ask it anyway. And this maybe is for Reeve and Sean. Is there any problem with having a vote on a recommendation after the time for the meeting, beyond the time that the meeting was set to end? Is it? I don't know the answer to that question. I mean, some people have certainly, some members of the committee have left, but I don't know. I don't know the answer to that. I haven't seen it happen, but I just want to raise that question, maybe for Sean to answer for us.
I don't believe it is an issue, Matt. Even though some members have left and some members have actually indicated that they're providing a proxy vote because they support the recommendation generally. But your primary question is whether or not we can extend the time beyond 1 o'clock. I think that's.
Well, yeah, but that's actually, I just want to clarify here. We have not extended the time by unanimous consent before the meeting time hit. So the question is, the time, the end date having come and gone, is it proper for the committee to vote on the recommendation during the meeting, or should it be done after the meeting by email?
Frankly, I think it's that decision can be made by the committee chair. I don't think there's anything inherently inappropriate about a vote taking place now, assuming that, you know, we have a representative number of committee members who are, you know, still able to vote. We can certainly, you know, another alternative is to request a vote by email within the next couple of days if the Committee on Style wants to tackle the non-substantive issues and send it around for a final vote.
Well, the Committee on Style, you are, all right, okay. With my comments.
I would recommend that we take a vote now if we have enough members. And if upon further research, you discover that we weren't able to take a vote now, we could always follow up with an email vote. But hopefully, if we take a vote now, we can be finished with the recommendation today. Does that make sense?
Yeah, and I would remind everyone that these committee proceedings aren't as formal as the plenary session. We're not necessarily governed by such formal rules as we are in the plenary session. So I think it would be fine to vote now.
Allison, do you agree?
Yes, I'm fine. I'm fine with that. So do I need to call for a motion, or can I just say call for a vote on adopting the recommendation subject to the work of the Committee on Style?
I wouldn't even do it subject to the Committee on Style. Yeah, no, that's fine. Allison, you can do it however you want. You could just ask if there's any objection to the adoption of the recommendation. Hearing no objection.
That was my initial. Is there any objection to adopting the recommendation? Matt, did I do that right?
I think that's fine. Sean, is that okay?
Sure. Yeah.
All right. Hearing none, the recommendation is adopted. I know we're past time. Just briefly, I wanted to thank everybody on the committee and also our guests who have contributed to what, for me at least, has been a very thoughtful, thorough discussion. I particularly want to thank George for his incredible work on the report for ACA staff. Carrie, I want to give you the opportunity to.
Yes, I echo everything Allison said. Thank you, everyone, and thank you, George and Gavin.
Thank you. And maybe I can, on behalf of everyone who's here and who was here, thank Allison and Carrie for outstanding work under a difficult timetable and at somewhat last minute notice. Thank you very much. You've really done an exceptional job, and I think everybody would agree with that.
Thank you.
Thank you.
Bye, everybody.
Bye. Thank you,
Guys.
everyone.